Good afternoon. Thank you everyone for making the time to attend. Thank you for what I promise you will find to be a very interesting and important topic. So the Convention on the Elimination of All Forms of Discrimination Against Women, more popularly known as CEDAW, was adopted in 1979 and remains the only global treaty dealing with women's rights. Singapore is a member of CEDAW. Known also as the International Bill of Rights for Women, it also established the CEDAW Committee, which has been generating jurisprudence on women's rights for over 40 years. Professor José Alvarez's book and research is very important because it draws attention to an important but neglected area of CEDAW jurisprudence, discussions on property rights. It in fact advances a definition of property that includes elements not usually linked to the concept of property, which I found very innovative. So I'm sure women and men want to know what your property rights under CEDAW are. I definitely want to. To explain this to us today, based on his groundbreaking research, is Professor José Alvarez from NYU Law School, who has written 6 books and over 150 shorter works on an impressive range of international law topics. He will be first giving a presentation on his new book, Women's Property Rights under CEDAW, and then Professor Niloufar Oral, the Director of the Center of International Law, and Professor Jacqueline Neo, Director of the Center of Asian Legal Studies, both who are experts in the area of women's rights in international law and comparative constitutional law, respectively, will then share some comments on his work. We will then open the floor for questions. So without further ado, Professor Alvarez.
So thank you so much for organizing this and giving me 2 illustrious commentators, which I hope to learn from. So this book does not come out till March of this year, but I have been giving talks around mostly Europe, actually, about this. I am pleased to say that not only is this the largest audience to discuss and actually show up for this, but the most diverse. That is, every single audience that I've had, which is less than 20, in every university from Padua to Bologna to Verona, have been almost exclusively women, which suggests that, at least in Singapore, you rightly accept the idea that women's rights are not just about women. So I will discuss and situate the book. There are parts of the book that I will not get to, including a whole section on feminist critiques of CEDAW that I think are only partly justified if you take a look at this jurisprudence, as well as a whole chapter that will interest people like Jansen in the audience, which compares CEDAW's property jurisprudence to investment law and its protection of property, and another chapter comparing CEDAW to the Covenant on Civil and Political Rights protection of property through discrimination and the Covenant on Economic, Social, and Cultural Rights. So this is just a few of the highlights. So the book deals with the gender of both property and wealth, which is a chasm. It's long been understood since, say, even in the 1980s, reports by the UN Commission on Status of Women, that women received only 1/10 at that time of world income, on less than 1% of world property. The feminization of poverty continues to this day, and you can measure this gap in gender of wealth and property in many ways. By who owns businesses around the world. Fewer than 12% of firms in South Asia have female participation in ownership, and it goes up to 18% in the Middle East or North Africa. But who has access to credit? Women virtually everywhere have less access to capital or credit than men because in too many places you have to have property to have access to capital, which is a bit of a circle, a vicious one. Women own 30% of registered businesses worldwide, but only 10% of women entrepreneurs have access to the capital needed to grow their businesses. By who owns farmland? Women make up 43% of the agricultural labor force in developing countries, but fewer than 20% are landowners globally. And that percentage is 10% in Western and Central Africa, as well as the Middle East and North Africa. by who has low-paying jobs, who are engaged in unpaid work, as in the home or in the informal sector. One way of thinking about this is my former good friend from the University of Michigan, Catherine McKinnon, who puts it blessed and bluntly: women are more likely to be treated as property than to have any around the world. So what this chapter does is to describe what we think is the property jurisprudence of the committee, the CEDAW committee, which has been around looking at this issue for almost 40 years directly. And the 6 chapters in the book are structured around that jurisprudence. The biggest chapter is a description of the jurisprudence written by a former research assistant, Judith Bowder. And then the other 6 chapters that I've written are analytical descriptions of what we can draw from that. And that's the focus of the book. But I think the book would be of interest to those who are just looking at the jurisprudence of the committee and can look up particular aspects. This, what I've just given you, and this graphic description, is contemporary reality. It is not old and therefore dated. In fact, thanks to COVID, thanks to other issues that we have seen, including climate change, the feminization of poverty, and many of the statistics that I've just described continue to this day. It's widely accepted that the gender property gap exists. And one thing I want to stress is that only one way of dealing with it is using human rights. So I'm just focusing on one tool, the convention, and focusing on human rights. There are many other ways that exist to deal with this, including, for example, the Sustainable Development Goals, which, as you probably know, has SDG 5, is on gender equality. But more importantly, the rest of the 17 SDGs, if you look through them, have 54 indicators that focus on gender, and it shows you that gender equality is the inevitable linchpin for virtually accomplishing everything in the SDG goals. And I hope you can see those links in this. That is, if you start with women's empowerment, it affects the level of education, nutrition, clean water, maternal health, agricultural, food security, community mobilization, health, microfinance. Every single thing turns, at least in part, on gender equality. Another way of seeing the same thing is this from LANZA, which is an NGO focused on land rights for women. And here they focus on the effects. That is, strengthening women's land rights would mean nourishment. Children whose mothers own land are up to, as you see in the first one on nutrition, up to 33% less likely to be severely underweight. Women who have land are safer. Women who have land also are healthier, including the whole family. They're more resilient to things like climate change. They're more likely to be educated and prosperous. So nobody questions, as a matter of policy, the significance of all of this. Nobody also questions that there are public and private solutions to this. The private one, as I've mentioned, is the SDGs, where the do-nots are in the X's. These are the things states should eliminate violence, eliminate harmful practices, recognize and value unpaid care work, ensure women's participation, and so forth. But also the reality that the private market, that is, the enterprises, also have lots of economically rational reasons to pursue gender equality, including, as you see here, the likelihood that you are a better corporation and more profitable one if you adhere to this. The other thing that I want to suggest is that among the solutions could be what the World Bank does. And here, I don't want to offend any World Bank aficionados, but I'm going to simplify a bit what the World Bank has done. The World Bank started by focusing on gender equity and then discovered that that didn't mean much. And so they changed to gender equality. Unfortunately, even though their rhetoric is very strong, their actual on-the-ground reform agenda tends to be something like this. What we need to do is get land titles into the hands of women, those yellow pieces of paper. And that once we register the land, once we make sure that women are counted as land owners, then we pretty much have solved the problem. Needless to say, that is not true. That is, getting land titles into the hands of women would matter if land titles matter. Also, it matters what the legal system does with those land titles. It matters what the social, cultural, and other conditions are in which land titles may be fully ignored or not considered. So yes, there are many places where formally, under the law, women have full equality, but they do not enjoy it, even if they may, in some occasions, have actual titles to land. Now, I don't want to poo-poo the importance of land titles. As I've just suggested, it is very important because, as you see in this table, there are 15 countries where women do not have equal ownership rights to property, 34 countries where daughters do not have equal inheritance rights, 35 countries where widows do not have equal inheritance rights, and 90 countries where customs intervene women's actual access to land. So this is a real problem. But one of the reasons that I think the World Bank has been properly criticized is because, to the perception of many people, the World Bank has adhered to this for all the wrong reasons. And here's one of them. Hernando de Soto's The Other Path. That is, this conception that the way to develop the world is precisely to protect private property in the hands of individuals and focus almost entirely on that, along with deregulation, let businesses bloom, and economic globalization. That is what you all would recognize as the Washington Consensus and its endless variations over time. Now, the subtitle to Hernando de Soto's path-breaking book, which has influenced NGOs, has influenced many other people, not just the World Bank, also tells you his conception. This was the economic answer to terrorism. That is, not only would protecting land rights protect you in sense of economic development, it protects you against extremists, which he called terrorists, and would ultimately protect democracy itself. And so that view, which is a pretty single-focused view of what it meant to protect property and how to do it, has, I think, led to many people being, as we'll talk about, being quite critical of the whole notion of international law protecting property, because they think about it in these terms. And I dare say, to some extent, the investment regime partakes of that vision and has also gotten a fair amount of criticism based on that. CEDAW takes a very different view of why we should protect property and what property is. So let's just encapsulate that. CEDAW, like the Covenant on Economic, Social, and Cultural Rights and some other treaties, have a three-point view of what states' obligations are. States are supposed to themselves respect all women's rights, including rights against especially discrimination. So states themselves cannot discriminate. States also need to protect women against private actors and others who would discriminate against women. So it's not just the obligation on the state, it's the state's obligation to protect from private actors. And even more radical, they have to fulfill these rights. There is a substantive, underlying, and basic level of women's property rights, as well as all the other rights discussed, that have to be fulfilled by the state if it's not fulfilled by the market, for instance. And what are those? So in our conception, these are the particular parts of CEDAW that protect property. And let's just say there are more of them than most people think about. And what is interesting, and I would appreciate hearing from you, is why, as you suggested, most people haven't written about this. So when I started this project, I was reacting to, well, I know what property rights are under investment law. I know what property rights under the Inter-American Convention are because I've written about them. And so I assigned a student, well, tell me what's been written about property rights under CEDAW. Answer, at least in English and a fair number of other European languages that my assistant can speak, nothing. That is almost nothing. It's as if it didn't exist. Now, when I approached Christine Chinkin, one of the leading feminists on the planet, who I've known for many, many years, about this, and I mentioned this a few years back when I was contemplating this, and I said, why don't feminists talk about this, and why is this not an issue? She revealed something that I now understand. She said, because we regard the protection of property in CEDAW as a mistake. A mistake. Now, why would that be? And I think I now know the answer. Because people associate international law of property with the investment regime, with all things bad. That is the notion that it protects a neoliberal conception and that the more important things are to protect women from all the other forms of discrimination. And I think that reflects a narrow view of what those other things are, the interconnectedness of those other things with property, and also a narrow view of, frankly, what the convention actually says. So as you see here, we're talking about the rights to not just assets, but entitlements that most countries would include as part of inheritance rights or part of your patrimony. And that's very conscious too. That is, what are property rights? Well, here's a list of them, even though the convention only says the word property in about 2 places. But I think under most national laws, the things that you see listed here would be included under the protection of property. And that means Social Security benefits, maternity leave with pay, whether they come from private entrepreneurs or the government, because CEDAW, as I've just mentioned, covers both. Other areas of social life, including Social Security programs, bank loans, mortgages, forms of financial credit that make it possible to have an economic life. And under Article 14, and this is directed, interestingly, on women in rural areas, but don't let that mislead you. 40 years of the CEDAW Committee's jurisprudence has expanded that beyond rural areas, and they have interpreted this to cover intersectional discrimination. That means women who are discriminated against because they're rural women, because they're single women, because they happen to be pregnant, because they are older women, various categories whose identities intersect, and the bottom line is they are discriminated against both de facto or de jure. And you see in Article 14 how broad that is, especially if it goes beyond rural women. So agricultural credit and loans, marketing facilities, appropriate technology, equal treatment in land, and things to help done by the state, including land reform, land resettlement. And then there is this phrase, adequate living conditions in relation to housing. So now we have equal property rights affirmed by a treaty with respect to adequate living conditions and housing, which is, most people think of, included in the Covenant on Economic, Social, and Cultural Rights, but is now here, at least when it's women that are adversely affected. And then you have the broad protections under Article 15 of equality before the law. Woman comes to enforce a contract, and there's some reason why that she cannot enforce that contract, that is protected, and I consider that a property right under CEDAW. Civil matters, legal capacity, rights to conclude contracts, to administer land. And then there's the very comprehensive Article 16, all matters relating to marriage and family relations. And trust me, a lot of family law is about property, including some of the most significant aspects of property law. And here it's a broad conception of ownership, acquisition, management, administration, enjoyment, and disposition. So that's the introduction to what the convention says. And then there is something you would learn if you paid attention to CEDAW over time, that this is not your grandfather's look, and grandfather is appropriate here, of formal equality. This is a look and demands substantive equality. So what does that mean? All measures by the state that advance de facto and not just de jure substantive equality, demands states to actually advance not just formal equality under the law, but that in actual reality, women actually have equal rights. And it addresses direct and indirect discriminatory distinctions. And notice, it includes not just the specific rights mentioned in CEDAW, but all other fundamental human rights. So Singapore may not be aware of the fact that through ratifying CEDAW, they have ratified, in effect, all fundamental rights, at least with respect to women, because that's what this convention is about. So that includes political, economic, social, cultural, civil, or other rights, at least to the extent they would be reflected under customary international law. And whether by public authorities or private actors, including actions taken outside the state's territory. Let's just pause here for the shock value to the private lawyers in the room. What we're talking about is if you have a corporation or a business incorporated in Singapore that happens to do business outside of Singapore, that corporation has to adhere to the same anti-discrimination measures outside the country as inside the country. Extraterritorial effect of human rights, as interpreted by the committee, which everybody calls, as everybody does in human rights jurisprudence, in this case, CEDAW jurisprudence, which is what this book is about. And it also requires the intrusion into the private sphere. Modification, and this I will say is the hardest part of CEDAW, modification of social, cultural patterns of conduct, elimination of all prejudices, customary or other practices or stereotypes, including inside the home by religious groups, including polygamy. You can just start spinning this out as applied to Singapore. See concluding observations 2017. And authorizing something else that's controversial in both this country and in the US. And by the way, the US is not a party to CEDAW. Doesn't have to worry about any of this. It can treat women just as poorly as anybody else, and worse. But 189 countries are parties. So this is one of the most widely ratified conventions on the planet. And a good chunk of them, over 120, have ratified the optional protocol permitting individual complaints to be brought to CEDAW. Singapore has not, and many countries in Asia have not. But, for example, Turkey has ratified the optional protocol. What are the implications of this? And I just insert one little picture to give you a sense of reality, because this is awfully abstract. This is a picture of a widow in India. In India, many parts of it at least, if you are unfortunate enough to have your husband die, you are ostracized from the community. You are put in a hospice with other disadvantaged women because your relatives will have nothing to do with you. Your property has been grabbed by the male relatives. So you no longer have your home, much less any assets attached to the marital property. Needless to say, this is the kind of customary religious, in this case, caste prejudice that CEDAW seeks to destroy, whether or not the law defends this, right? It doesn't care. CEDAW doesn't matter whether it's the law that says this happens or whether this is the product of custom. And it's not just, of course, in a place like India. There are many other places where older women have faced these kinds of horrors. And so what is the CEDAW's property jurisprudence? Where do we find it? Fortunately, it is all very public and easily accessible. They are basically general recommendations. And if you look at the annex to our book, we put them all out there. 17 general recommendations over time. These are the lengthier discussions where CEDAW tries to explain the law with relating to this. 17 of them deal with property. Hundreds of concluding observations that deal with property in response to state reports. That includes, of course, Singapore's, Turkey's state reports, because they have to file them every 4 years, I believe it is. And of course, some are late, and sometimes they take years for the CEDAW committee to report on them. But hundreds of specific concluding observations that say this practice or this thing that you are doing, law, custom, whatever it is, violates CEDAW for the following reasons. 15 views. This is the most unsatisfactory part. What are views? Those are the equivalent of case law, individual complaints. I've just told you over 100 states have ratified the optional protocol. There's a chasm of property gap in the world, but only 15 complaints. Where are the lawyers? Where are the private lawyers bringing these complaints? And the answer is they're not there. That is, in most places of the planet, women face these constraints and have no idea that they have this right and no idea how to access it. So if you look at the 15 individual views that deal with property, which is what we're dealing with, most are in Europe. That is, most are because of an NGO that is devoted to helping women access CEDAW. But even in Europe, 15 is nothing. There are also 2 inquiry reports. Those are very serious systemic consequences, in this case, South Africa and Canada, of all places, where the state has agreed to an inquiry based on systemic violations, and 2 of those inquiry reports have to do with property. And what do they deal with? Well, as you already can predict, and I don't have time to cover all of this, but these are the many different areas where property come up. Most common is marriage and family relations, but also just generally civil and political rights, land rights, adequate housing, intellectual property and seed rights, access to credit, social benefits of all kinds. And then, interestingly enough, is the last one, gender-based violence. So CEDAW was criticized because it does not have any guarantees against gender-based violence, as if that was not a discriminatory thing. Over time, the CEDAW committee has corrected that gap. And so they now accept that the absence of a state action to, say, issue protection orders in connection with domestic violence is a violation of CEDAW, and that in itself is a discriminatory act. Along the way, not only have they incorporated gender-based violence as a violation of the convention, but they've also incorporated property rights, as I'll mention in a few minutes some examples of that. So if a woman faces a protection order or is given a protection order, but that protection order is not enforced because the husband, the abuser, has the lease of the property, the apartment, or owns the house, then she cannot defend herself from entry by the husband. And so CEDAW says, we don't care about the property rights of the abuser. That's one difference between CEDAW's conception of what a right to a home and tenure security means, as opposed to more traditional, where whoever owns the home, whoever has the leasehold, has the property rights. CEDAW ignores that because the ultimate result is violence and perhaps death has happened. So I'll give you a sense of some of the selective views. So property rights in marriage and family relations, including Tanzania, typical instance of women in Tanzania whose property was grabbed after a death in the family. And so a typical instance of what I just described for India, and that was a case in which Tanzania was found in violation. Adequate housing. This is particularly interesting, North Macedonia. So here, groups of Roma women, and they brought the complaint. They were all either young mothers who had just given birth or pregnant. They were living in unauthorized, illegal shelters in a city in North Macedonia. They had no right to be there. These were, as you can imagine, the kinds of shelters you see all over the developing world. And suddenly, one day, without notice, cranes appear, demolish all their homes, and they have no place to go. And so ultimately, they go to CEDAW, filing a complaint, and the Roma women have found to have been faced forced eviction, and a forced eviction without notice violates the convention. This is interesting because these people have no rights to be on the land, and under certainly most law around the world, they would have no right to ignore an eviction order and no right to stay on these shelters. In that case, the CEDAW committee says, if you don't provide private housing, then your government must provide adequate housing in light of the adequate housing provision, and adequate housing has to be appropriate to the needs of these particular women. That is, childcare, that is, access to health care if they're happen to give birth. So sensitive to the particular conditions and adequate housing for those women. And this also affects even much more developed countries that are very proud of their pro-women gender equality positions, like the Netherlands. Well, the Netherlands, like many countries in Europe, have pension rights that only kick in if you have contributed for, say, 7 years under a formal investment scheme with formal pay. Well, it turns out that a number of women could not get any kinds of pensions because, like many women, they were at home taking care of a sick relative or taking care of a handicapped child, because guess who gets stuck with that, right? Because men are working. Women who do this are not working, according to the Netherlands law, and therefore they're not entitled to pension rights, at least for those years that they were there. And in this case, they were not entitled to pension rights at all because they didn't have the satisfactory number of years. And so that was found, and not just there, but in Moldova and a couple of other places, to violate the CEDAW. And then there are rights that are more like this. This is gender-based violence. These are cases where the lack of protection order or the lack of police enforcement of a protection order means that women face death or the regular threats of violence because they were not protected with access to their home. This situation is, of course, common all over, so I couldn't help but include this picture. It won a Pulitzer in the United States, not a party to CEDAW. If you look closely, the woman has a black eye, she has faced violence, and she had to work extra time to devote to find the money to change the lock on her door herself, because nobody else was going to do that and protect her. That's the kind of thing that is endemic in both rich and poor countries around the world. So I've given you a sense of what the committee does, but let me just say a few words about that I can't really address, and that's all these critiques of CEDAW. And what I would say, and I welcome questions about this, is that all of them are a bit of a lie. A bit. That is, there's a truth in every aspect of them, but the truth now is, after 40 years of jurisprudence, the committee has corrected many of these flaws. That is, it does not insist that women are treated exactly like men. In fact, they sometimes want women to be treated, what you would say, better than men, because they face different structural and other impediments. So it is not equal sign men, women. It is not that automatic and also not that binary. It also is not about protecting the rights of some essentialist woman on the model of a European woman in France. That is, the committee now has 189 parties. The committee's composition is as diverse as that would suggest. And so they are very sensitive to the very different contexts around the world, including Muslim women, etc. And therefore, this is not about exporting European standards to the planet. And there's also, and remember, with all of these, there's both the truth and non-truth. So does it marginalize women's rights? Well, it does mean that this is a treaty devoted to women. This is a convention and a committee devoted to women. Therefore, you could argue that that means that the ICCPR and all the other committees are off the hook. But the problem is that when they were on the hook without CEDAW, they were ignoring women's rights. So I'm not sure what to do with the marginalization complaint. I think it still is true. Fortunately, this audience suggests marginalization isn't quite as bad as it was all over Europe when I was giving this, but marginalization is still an issue. That is, many people just don't think this is their problem, or that economic development is really a women's equal rights issue, which I think CEDAW committee would say very much it is. And so you can see that the bottom line under this feminist critique, and this includes Hilary Charlesworth and Christine Chinkin's wonderful book, The Boundaries of International Law, does convey these critiques. They are quite skeptical as of the year 2000 of the convention along these lines, and they would argue, along with many other people, that basically CEDAW is insufficiently transformational. And so the other critique is, I think, the one that I might say a bit more about if I have time, but I think I don't, is this. This is broader critique, not a feminist critiques, but the neoliberal critique, among others, that it advances the privileging of private property, encourages commodification, privatization, deregulation, globalization. In other words, the Washington Consensus and everything else. I don't have much time to address this, but I think that is completely wrong. That is, this is not what CEDAW is about. In fact, on almost every one of these, it does the opposite. So that's what the Chapter 5, comparing the investment regime and CEDAW, does. It compares the two and says, this is what would happen under the investment regime, this is what happens under CEDAW. It does not, in my view, just simply entrench market economies. It does not simply ignore the structural roots of women's subordination. It does not necessarily deflect attention from market actors. These are all the critiques that I think are a little off. And here's the last two. So if you pay attention to people, so this book, by the way, is Jessica White, The Morals of the Market. What it portrays are the Chicago economists going to Chile and selling shock treatment. And that's how she interprets human rights. Human rights is basically shock treatment by another method. And that what Chile faces is what the world faces if it follows human rights, if it follows including CEDAW and protection of property. And I think that's exactly wrong. That is not what this, at least this regime, is about. One of the reasons this argument is made is because the people who argue this say it legalizes what ought to be political. So that if you pursue CEDAW and protect property as a human right and take it seriously through lawyers, through a committee, and through legalistic processes, you are now going outside the street, ignoring demonstrations, political mobilization, which is what would really, truly transform a society. What I've seen is that both happen. That is, because you have legalized human rights, you encourage some of these political mobilizations. It is not a binary, just legalization, no politics. It goes together. In fact, if we've learned anything from the backlash against human rights, it's because human rights are so political that there is a backlash. right? So that's my answer. And the same with internationalizes what needs to be local. The argument is, why go outside the state through CEDAW to, instead of political battles inside each country, to make sure you change the local law? And the truth is, as you see with CEDAW, it's both. That is, national courts, in over 300 cases we have seen, have picked up on CEDAW's jurisprudence to reinterpret constitutions, to reinterpret national laws. Legislators have been inspired to change law because of the international system. Again, I would quote Catherine McKinnon, who basically says that women frequently have to go outside the state to get justice inside the state. CEDAW is one place they do so. So this gives you a sense of the critique and my answers, and lessons from the jurisprudence are these. I don't have time to cover them, but essentially it's a lesson that, like everything that you hand over to a quasi-judicial body like the CEDAW committee, it evolves over time, like a constitution would, like a statute would. And so the CEDAW Convention of 1979 does not give you a firm grip on the property jurisprudence of 2024. And so a lot of the original difficulties, not all of them, have been overcome, including this neoliberalism agenda, and that it takes very nuanced positions on public and private, and that's one answer. But of course, when you study subject, you don't celebrate it. I certainly don't. And so this is the part that will make me unpopular with some CEDAW buffs, which is where I criticize the CEDAW. And let's just say, if you're a student of, as I am, of Max Weber, this is no surprise. If you create a bureaucracy, boy, you've created a problem. And this is a bureaucracy. It is embedded in a bigger bureaucracy called the UN system. Both are horrors, right? I've devoted my life to describing the UN, but let's acknowledge it's a problematic system. The problematic aspects are, some of these are listed here in rather anodyne phraseology. So when I say UN imposed constraints before, in, and after Geneva, what I mean is the UN bureaucrats determine what an admissible complaint is to the committee. And somehow they ignore the absence of lawyers. So if it's not a heavily lawyered complaint with elegant language, it disappears, and nobody tries to ask the question, can we provide some lawyers? Because there's no technical assistance attached to CEDAW, because there's no budget for it. Also, it's the bureaucrats who decide how much time CEDAW has to devote to this session in Geneva. I'm sure Nolifer is familiar with some of those constraints. That is, constraints on how many words you can use in the views. I think it's 10,000 words and no more, or in concluding observations, or in how many hours you can devote. Then there are constraints imposed because CEDAW itself has constrained itself. That is, this is a heavily legalistic process. And yet, who writes these views, who writes the general recommendations, are not always lawyers, right? This is a diverse composition of people with very many different skills, which may be helpful for many reasons. But let's just face it, if you want a judicial or a judicial-like opinion, don't have it written by a sociologist, right? And so you have opinions that are not well developed. X v. Cambodia, look it up. You will see, if you're a lawyer and you read X v. Cambodia, which is a case dealing with a woman who her rights to her rural land was taken away by a company that happened to be partly owned by, I believe, the Minister of Interior's spouse, and therefore got a land title that they were not entitled to, went in, bulldozed their way in, destroyed the private titles located in the homes, and then claimed they had the right to those lands. She struggled to present this case and presented it beautifully to the committee, And the committee agreed with her, but that's all they did. In other words, they took the complaint and repeated it as their judgment. Let's just say most lawyers would not be happy with that on either side. Part of the reason, Cambodia never showed up, right? And so, okay, well, Cambodia didn't show up, so they obviously have no defense, and therefore we have nothing to say about this. Now, if that had happened in the ICJ, you know what the ICJ would do. See the Nicaragua case, they would try to figure out what the positions of the absent party would be. The CEDAW committee does not always act in a way you would expect a court should act. And then there's sovereign backlash against human rights, which of course the CEDAW committee is suffering from, cutbacks in terms of the time that they can spend on these issues. And then there's a perennial issue throughout international law of fragmentation. CEDAW is only one conception of property rights. It has to live in a world where there's investment law pointing, in some cases, the opposite way. And so that's fragmentation. It also is, to some extent, fragmentation among human rights regimes in terms of remedies, say, for collectivities versus individuals. So those are some of the problems. And of course, the last one is pathologies and path dependencies. The CEDAW committee is like every other bureaucracy. We did it that way last year. It didn't work, but let's do it again, right? And also a lot of deference to states, depending on the state's power. So it's really very gentle on China. I wonder why, especially given the amount of money China devotes to the human rights processes. I think I understand some of the impediments there. So we have these kinds of things that result from everything that I've just mentioned, which is basically we have inconsistencies among the jurisprudence of the committee. So the general recommendations are quite elaborate, but they're not always carried out in the views. They're not always carried out in the concluding observations. And because of the way the committee uses those precious time with state reports, they don't always focus on the most important things. Believe it or not, state issues its report, and now the committee is going to issue its views, and they will proceed article by article from Article 1 through Article 16, even though Article 16 may be the most important, but it's 16. And guess what? We may run out of time by the time we get to 16, or it'll have to be a very short concluding observation like, we don't like that, period. And so with China, you get something like that. This is a country that is very proud of its gender equality. However, if you actually look, if you are raped in a marriage in China, good luck. There is no prosecution of marital rape. If you seek a divorce in China and you're a woman and don't have the consent of the husband, good luck, because China has discovered it needs to keep marriages intact because it has a bit of an aging issue, and everybody should just have children. We changed our minds on the one child. Now we want everybody to have children. And therefore, marriages are encouraged to stay together even when there is serious, proven domestic abuse. So guess what happens? A woman facing domestic abuse has to get out of a marriage, but she has to get the consent of her spouse because that's the only way to do it. Guess what the spouse imposes? Give me all the marital property, thank you very much, maybe the custody of the children, anything I can think of, and I'll say yes to the divorce. So that's a typical scenario in China. Lots of books written about this. The committee knows this, and yet the most recent report simply reports, you better do better, China. That's it. It doesn't give you much of the substance or the reasons why the law is not being complied with. So let me end with a promising note, which is, despite all these problems, I actually think there is a transformational promise, at least in the formal jurisprudence of this body. If you take its jurisprudence seriously, this is something that would transform a state. It would transform the position of women and also men. It would also mean that we would have sufficient property, not just, quote, equal, formally equal. It would prioritize women's equality over family unit, very controversial, but also over economic globalization. Because the committee will say no to the entry of a big agro-business, even if that would grow the economy, if it puts all women-owned family farms out of business, because it cares about prioritizing women's rights. That is not the world of neoliberalism. It also does this. This is just a huge laundry list of all the intersectional identities that the committee over time has discovered and think is relevant. And it means that it is not just exporting a single view of women in Europe to others. It considers all of these identity role models, roles of women, including their roles as human rights defenders. So, and I'm sorry I'm running a little over time, but so almost everybody, at least in the US and the UK perhaps, is familiar with this book. That is Virginia Woolf's memorable essay/book from 1929, A Room of One's Own. Virginia Woolf argued, and this is a conical feminist essay, that female writers like herself required personal space, possessions, to enable autonomous self-expression. She said that there were many contrary instincts, translate discrimination, that would have prevented, for example, Shakespeare's hypothetical sister, say Judith, should she have tried to become a writer equivalent to her brother. She argued that women writers needed certain necessities, a room of their own, a lock for that room, along with a certain amount of material possessions, including money, to apply their craft. I imagine that this is the kind of room she had in mind. In 1929, musical accoutrements, some inspiration from art, probably a garden outside. And yet, that's not the world that most women ever see in their lifetimes. So what does CEDAW do? And by the way, this Woolf's essay has come under criticism because, of course, what her vision of what women enjoyed in England was based on colonial dispossession, and she enjoyed a lot of stuff because it was stolen from lots of other places, right? But what CEDAW does, it does agree that women need the equivalent of a room of one's own, but not necessarily exclusive possession, and that it extends to the planet. And so I think this image more accurately captures what the CEDAW committee is trying to do. And I purposely picked the controversial image from Europe, where wearing this outfit will not get you rights. But CEDAW does not emphasize that. CEDAW says, we don't care if you're Muslim. We don't care if you wear the hijab. You are entitled to property. And so with France, it actually asked them, can you give us some information on how your secular policy is working out, France? That is, tell us whether women are still equal and enjoying the full benefits of what the convention gives. So that's the transformational promise. Alas, the criticism of CEDAW suggests we're torn between these two images. The cover of my book is the optimistic one this is Wanshi Mutu, a Kenyan-American artist, very well known, and it's an optimistic image of what CEDAW can produce. But the same artist did this, and that's the image that the critics of CEDAW, including Marxist critics, would say, that unless you cut the snake of global supply chains, unless you make sure that we end capitalism and market capitalism and empowering women under markets, you will never have the transformational equality. As I've given these talks, the few women that have showed up seem to think that was too extreme, and that I'm closer to the right track. But I throw it back to you. That is CEDAW too much caught in the market and economic empowerment of women under the conception that most states, like it or not, whether they identify themselves as communist or not, are truly market states? And that if you think that this is necessary, the only hope is, let's see, Cuba, North Korea, perhaps, and that's where we'll see women's equality. I'll go with that one, the other image. Thank you very much.
So thank you so much for that amazing lecture, Professor Alvarez. I've always thought that the CEDAW committee's jurisprudence is very humane and transformative, but it's focused on root causes and transformation. And I really look forward to your book coming out. I would now like to invite Professor Nilofer Orel to give comments and on the fascinating book.
Thank you, Wei Ling, and good afternoon to everyone. And wow, can I say what a fantastic lecture that was. Truly a tour de force, and I mean that. I learned so much, and I think you breathed in new life and a different life to CEDAW. It's been a long time since I've looked at CEDAW, frankly, and I see that you captured an aspect of it that, as Wei Ling said earlier, property rights has really been overlooked. And for women, and clearly it is so important. And I have to say that I feel after this really very powerful lecture, it's hard to follow up, but I'm going to speak a little bit about Turkey. And I think it's interesting to look at Turkey from the context of women's rights and property rights. And of course, Turkey's a party to CEDAW. And the reason is that Turkey, last year, 2023, celebrated its 100th anniversary of becoming a secular republic. Because Turkey came out of the Ottoman Empire, and the Ottoman Empire was ruled by Sharia law. And so, of course, if you've been to Turkey, you meet Turks, I think one of the common threads is the founding father of Turkey, Mustafa Kemal Atatürk. And he understood, interestingly at that time, that in order for Turkey to become a modern state, women had to be equal with men. But I'm not going to go into that. But this impacted the change in law. And so what happened was, in 1926, Turkey adopted the Swiss Civil Code, actually. So it was for many, many years verbatim, mutus mutandis. And of course, here, and under the Civil Code, under the Turkish law, it also recognized that women had equal rights to own and control land. This was also constitutional. And then in 1930, Turkey actually gave full political rights to women, and at the national level in 1934. Now, let's fast forward to the year 2002, and this is an important year in Turkey because this is also during the period of believing that Turkey would become an EU country. So this is a period of accession. Lots of things are happening in Turkey at that time, and the Civil Code went under revisions. And under that, women's rights, including in the broad sense, as Professor Alvarez has said to us, strengthened property rights for women. So for example, marital property rights, until then, they were separate. And what that favored, of course, was men. That if you kept it separate at a divorce, then the men get to keep everything. It was changed to more or less a community property system. And so the property that was acquired during the marriage had to be split, but the separate property would be kept. But I just wanted to give, it's actually a true case of what happened. So in Turkey as well, they have dowry. And I'm sure in Asia they have dowry as well. And the tradition is that at a wedding, particularly in Anatolia, but now we see it in Istanbul, at a wedding, gifts are given and gold, prized possession. You see brides, they're draped in gold. So apparently there was this man who had unpaid debts, and there was a court judgment against him. And it just so happened they decided to enforce it in the middle of his wedding. It was on television. And they actually seized the gold that was on the bride's neck. That went to court. And I have to say, the court ruled that this was her separate property. So her rights were protected. So I say that it's a true story, but it's a bit humorous as well. Now, Turkey had a reservation to CEDAW. It's a party. And in that reservation, I believe it was in 1990, I think it's in your book as well, that stated that husbands were the family head and made all decisions. So until 2002, the head of the family was the male. That changed. So after 2002, they shared this. The union or the marriage was jointly managed. And also, until then, women had to get the permission of their husband to work. And that changed as well. So we see, because work also, the right to work is an important property right. And these were all made because there was very strong women's movement in Turkey. Strong feminist, still is, very strong. Also the European accession, but also CEDAW. CEDAW is an important, and I think the Turkish women are very active in CEDAW as well. I don't want to go on too long, but I just want to give a little bit of examples. So the inheritance, how women's property rights are protected under Turkish law. The inheritance is families protected overall. It's very difficult to disinherit your children in Turkey, practically impossible. And the spouse, both women and men, of course, are guaranteed at least a quarter of that. And if the spouse dies without issue, no children, then 50%. And this is really inalienable, except during the lifetime they can, get rid of the property. That's the one thing. Pension rights, very important. So just to give you an example, this was before CEDAW. In 1970, sometime, a law was passed that in order to protect unmarried women, whether they were never married or widows or divorced, they could receive the pension of their deceased father. So my mother, who's 86 years old, still gets the pension from her father, who died many years ago. And it was specifically to protect women. And I understand that there's also a law for Turkish homemakers, the women homemakers, to also have independent pension capacity as well. So these are all very important laws that protect women's property rights. And I won't go on more, but then, and I think this is exactly the important point, there's the de jure rights, and then there's the reality of culture and tradition. In the cities, women are more protected, I would say, in enforcing their rights, but let's go to the more traditional, conservative, Anatolia, Eastern, or even the Black Sea region, very different. Yes, the law is there, but the reality is that those laws are not really being implemented. And I think the problem is the women would be afraid to go and enforce those laws. Dare they go to the court would protect them, but dare they go? And so this is one of the problems, and I appreciated very much the critique you made and the weaknesses of CEDAW on this point, and particularly the lack of lawyers and technical assistance. And so even though this was a study done, it's a bit of an old study, but I think it probably still holds true in Turkey. Even though I've said this wonderful landscape of laws and women get all these property rights on paper, they did a study, and it parallels your work, over 80% of women didn't have property, real property, compared to about 40% for men. So there's a big gap in between. Although I will say this, this is my last comment, just to end on a slightly humorous note. So before Turkey became a tourist destination, the women, the girls, were given what was considered then to be the less valuable land. And the boys or the men were given the agricultural rich land. But guess what happened? The Turkish Mediterranean, much of the land was given to girls for that reason, the coastal beach areas. And that became very valuable. So sometimes the discrimination can actually go the other way. Anyway, I want to end here simply saying that Turkey is an example. One, it's a principally Muslim country. It's a secular country. We'll see, although religion plays a very important role, tradition. It has great laws so far. Hopefully that won't change. But it does come down to this issue of how to really implement and make sure that women are protected. And I think that this is something that I will also look into more in the property aspect, because again, I have to thank you. That was absolutely a brilliant lecture, and I learned a great deal. So I hope I didn't go too long, but thank you so much.
So let me just echo what Nilofer said about the book. I learned a tremendous amount, and one of the things I think, someone who used to work on CEDAW, but now am a full-blown constitutional lawyer, comparative constitutional lawyer, I'm going to make 2 points, and I believe Professor Cole might look upon this with disapproval, since he is a man of always 3 points, right? That's your style. But I'm going to make 2 points here today. The first one really is the paradigmatic shift that I think this book can provide us. I think the question that we should ask ourselves after today's lecture and after reading the book, I had a sneak preview, although I looked at it very quickly, was to ask ourselves, what if CEDAW used property rights as a central concept and not just see it as part of CEDAW, but as a central part of CEDAW? How would that actually change the way we think about women's rights? Bearing in mind, of course, CEDAW has a very strong emphasis on non-discrimination, right? After all, it is in the title of the convention itself, CEDAW, anti-discrimination. But sometimes an undue focus on the idea of non-discrimination as a negative liberty can then blind us, I think, and this is where the book really comes in, to the vast emancipatory potential of women's rights. And again, we should be asking ourselves after today's lecture, what if property rights becomes central to the way we think about women's rights? What would that change? How would it change the way not just CEDAW committee produces its concluding observations and also its judgments, but also in terms of how we, the state parties, would report on where are the improvements in terms of property rights, where are the improvements in terms of how women have home ownership, what kind of property rights do they have, and so on and so forth. So one of the areas I think would be very interesting, and in fact, somewhat raised in the lecture, is if Article 16 is about equal rights to family, in family and in marriage, right? And we typically think of this as rights of guardianship, rights of custody, rights to a certain sort of duties as well as obligations within the marriage. But how about rights of marital property? The access that one should have to marital property. And again, I think this is where I really found this book very illuminating, because it got me thinking about home ownership, let's say in Singapore. So I looked at our last 2021 CEDAW report, and this was actually not directly addressed. The question of what is the percentage of women in Singapore who own property? And I understand that you take a much broader view of what is property, social security, and all of that. And we do have some of these issues mentioned, for instance, in our Central Provident Fund, which is not quite a pension, but compulsory savings. There is this question of, what if you're a homemaker? How do you actually get access to those funds, right? But thinking back in terms of marital property and in terms of home ownership, this is actually something that I believe the World Bank tries to report on, but if you look at the gender data reports, there is not enough information, country-based information about what is the degree of home ownership or property ownership among women across the world. Only very few countries actually provide this kind of information. So this is where I think if we were to sort of broaden our lens to look at property as a question of gender equality, as a question of women's rights, we might see, for instance, I think, believe those in Singapore might actually think, actually women do have quite high levels of home ownership in Singapore. And why is that? And that actually is a function of our public housing policy, where in order, as you all know, to apply for public housing, you need to form a family unit, right? And to form a family unit, okay, we are still very conservative there. You need to have, a marriage, or you are a parent and a child. And considering that the majority of Singapore residents live in HDB flats, the home ownership rate of 89%, you're seeing a very high rate of property ownership, home ownership among women. Now, again, the second second point that I thought about was how we also have a common law rule of property. See, this is where your property laws actually do make a huge difference, right? Because we have a common law rule of joint ownership, which then means that if a spouse passes on, you actually retain ownership of the entire place. Now, I'll tell you one sort of significant way this has actually made a difference. Singapore, understandably, has certain reservations to Article 2 and 16 on the basis of our Muslim minority. But did you know that actually the common law concept of joint ownership applies in priority to Muslim inheritance laws in Singapore? And that actually is a way in which women could attain sort of broader, bigger property rights on the basis of these common law rules. So what I want to sort of emphasize in this is that if we were to broaden our lens, we actually see many more ways in which gender equality can actually be advanced, and ways in which it has been advanced, which we could actually discuss. My second point really is to think about, to draw some comparisons with constitutionalism, which is really my area, right? One of the discussions we are starting to have, and I'm proud to say I'm one of those who are having this discussion in the scholarly world, is the question of the constitutionalism of care. The idea that perhaps our constitutions focus too much on certain aspects that are insufficient to account for the good life, for a good constitutional order that will benefit those who are really in need. And so this really is a conversation that has been started before. Carol Gilligan and some of the, and others have actually started, or Helen Irving have already started this conversation some time back. But I think what COVID-19 really drove home is the fact that some of these beautiful civil political rights that we have in our Constitution don't help us when we have a crisis like the pandemic. Things that matter during the pandemic that do account for what people need under those circumstances are things like healthcare, things like housing benefits, things like childcare, and so on and so forth. So I think the emancipatory potential of CEDAW needs also to be transformed into the constitutional sphere. And of course, this has been a conversation that is ongoing, but to be transformed into the constitutional sphere to really, in both these areas, rethink our epistemology of constitutionalism as well as of women's rights. And so I wanted to end by answering the question that you asked, whether or not CEDAW is too much caught up in the market, whether we need to completely subvert the market. If I may, and I will say I'm not a neoliberal in so many ways, and of course, as someone who lives in a former colony, one should not be too much caught up in the neoliberalism. But the answer, I think, at this point in time, when it comes to women's rights, is it is not enough caught up in the market insofar as not sufficiently addressing the inadequacies of the market in correcting inequalities for women, especially with regards, after your talk, to property rights. So thank you.